Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled The Far from Helicon Island, Maritime Liens, Renvoy and Conflict of Law. So this is the fifth part of the video. The right to proceed on a maritime lien will now need to be viewed in this country in the prism of whether is the matter that affects the existence, extent, and enforceability of the right or duties of the parties. As a result of Zhang the Lex Loci Directive, the law of the place of the tort was the substantive law for determining the parties' rights and liabilities in respect of foreign tort. Thus, Chinese law applied. The question, says Nielsen, was whether the renvoy provision in Art. 146 should be recognized in the Australian proceeding as authorizing the use as the Lex Loci Delicti of Australian tort law and limitation provision. The distinctions between the domestic law of the foreign jurisdiction and its conflict of laws rules may be not easy to draw. To draw such a distinctions invite difficulties of the same kind as have so long attended the distinctions between procedural and substantive questions. But even if those difficulties could be overcome, why should a choice of law rule which provides that the rights and obligations of the parties to a proceedings are to be resolved according to the law of a foreign jurisdiction refer to some but not all the right foreign law in deciding those rights and obligations? Why should choice of law be premised upon the result of imposing on a foreign legal system a divisions which that foreign system may not make? Those questions are not be answered by choosing one theory of renvoy as the premise from which subsequent argument proceed. Choosing a single overarching theory of renvoy as informing every questions about choice of law would wrongly assume that identical considerations apply in every kind of case in which a choice of law must be made. But questions of personal status like marriage or divorce, questions or successions to immovable property, questions of delictual responsibility, and questions of contractual obligation differ in important respects. Party autonomy may be given much more emphasis in questions of contract than in questions of title to land. Choice of governing law may be important in creating private obligation by contract, but less important when the question is one of legal status. Choosing one theory of renvoy as applicable to all cases where a choice of law must be made will submerge the differences. If it be accepted that one object of a choice of law rule is to avoid difference in outcome according to selections of forum, then the objective ought to be to have an Australian court decide the present case in the same way as it would be decided in China. Guo and Heine J.J. discussed the principle and academic theories concerning renvoy in some detail. They said that their scholars had focused more on theoretical explanation that was in contrast to the principle and essentially practical concerns of the court to decide controversies as they arise in proceedings. Their honors identified three premises, namely that first, parties should not be able to obtain advantages by litigating in an Australian forum that were not available for the court of the place of the governing law. Secondly, whenever reasonably possible, certainty and simplicity are preferable to complexity and difficulty, and that the court of the forum should assume that the governing law's legal system is one constitute the independent rules. And thirdly, an Australian court must determine as an element of Australian law the source and context of rules governing the right and obligation of parties to a particular controversy. The reference in the second premise to simplicity, of course, harkens back to one of Lord Diplock's principal justification for the major choice of the law of the forum as being determinative of all questions in relation to a maritime lien. When the court of the forum is called on to decide the right of parties to a contract that is governed by another law, it must arrive at a method of resolution that an objective person in a position of the parties at the time of the contract would have understood from what they said and did. Ordinarily, it will surprising to commercial parties to a charter party or a standard from contract used in international commerce that expressly provided for English law to be applied in London arbitration. The evident intentions in stipulating for a congruence in governing law and jurisdiction is that the resolutions of any dispute would be the same whether or any party or aspect of the dispute had a foreign element. There arises the questions why, absent some clear contractual indication, would the court of the forum be entitled to conclude that, where the parties choose a governing law but omitted a choice of jurisdiction, they intended that their dispute would be decided randomly, depending on whether the private international law rules of the forum accepted or rejected renvoi in contract. Such a result would provoke uncertainty rather than give effect to the intentions of the parties that the governing law would yield the same result whether or not the law of forum was the same as that of the governing law. Different consideration may be opposite in situation where a court determined that a governing law different from that of the forum applies to a contract that itself is silent on a choice of law. In example, when the court applies the test for ascertaining governing law identified in Boniton v. the Commonwealth, namely that the governing law is that with the closest and most real connections with the transaction. In such case, the court of the forum and not the parties determines the system of law that governs the dispute. The precise way and the relationship in which renvoi applies in Australian law has not yet been fully worked through by the court, as is explained in ch. 15 of M. Davis, Aspel, and PCJ Brereton. This is not surprising since it was not necessary to set out the prescriptive formulation in Nelson. Indeed, ask a more practical solution necessary to decide the particular controversy. Can the doctrine of renvoi apply the contract? Do Australian conflict of laws principle require an application of all what is found to be the governing law, including any foreign choice of law principles with the consequence that rights, including maritime liens, may be created by force of the law of the third state, or is the law to be applied for the dispute on the domestic law of the forum? Furthermore, should a distinction be drawn between the contractual dispute involving the express or implied choice of law and those which require the court to find the governing or proper law of the contract? So the time is up and the article will be continued to read on the next video. So bye bye, and don't forget to like, comment, and subscribe. Bye.